55, specifying that sheriffs have liability for official acts related to charge and custody of jails. And with that, a bill brief from the reviser.
Thank you, Madam Chair. House Bill 2155 amends KSA 19811. This is the statute that provides that the sheriff has the charge and custody of the jail of the sheriff's county and over all the prisoners in that jail. Current law there provides that the sheriff shall keep such jail himself or by his deputy or jailer for whose acts he and his sureties shall be liable. This bill would specify that the sheriff shall keep such jail personally or by a deputy or jailer for those official acts that the sheriff and sureties of the sheriff shall be liable. So essentially just adding that official language. This change would align the language of this statute with the current law in a different statute, KSA 19805, which provides that in addition to the undersheriff, the sheriff may appoint, promote, demote, dismiss additional deputies and assistants necessary to carry out the duties of the office for whose official acts the sheriff is responsible. And I can take any questions.
Thank you. Committee questions. Senator Reichman.
Thank you very much, Madam Chair. I guess I just ask you, I guess I could ask proponents, but why do we need this bill?
Madam Chair, Senator Reichman, I will let the proponents get into that a little bit more, but essentially it's just aligning it so that, you know, the responsibilities are just for your official duties, not other duties, just to make those statutes match. But in terms of how that changes the policy and how they're going to, you know, if that changes their operations, I'll let the proponents kind of talk about that.
Is it to protect then the sheriffs and their office from claims against them in their unofficial capacity?
Exactly. Yeah.
Okay. Thank you. Other questions? Not seeing any. Then we will hear from our first proponent conferee, Sheriff Jeff Easter, Sedgwick County, on behalf of the Kansas Sheriff's Association. Please introduce yourself and welcome to committee.
Well, good morning, Madam Chair and committee members. I'm Jeff Easter with the Kansas Sheriff's Association. I appreciate the opportunity to speak to you today. I will try to answer one of the questions that was asked earlier. In the written testimony, you'll see that in 19805 that we're responsible for official acts that are conducted by our deputies. So anything that is an official act, you know, a car wreck that we're involved in, patrolling, those type of things, we're responsible for those. We get sued for those. In 19811, and remember that these particular acts were developed in the late 1800s. That's why you only see he in there. It does not have the same language as official acts. And so we're asking that that term, official acts, be placed in 19811. Also, since starting in 1933, there is 3 Supreme Court cases here in Kansas. Hitzman versus Kennedy, Libby versus Schmidt, 1956, Monroe versus Darr in 1977. Each of these cases clarified that sheriffs and their appointees are responsible for the official acts of their deputies. So what we're talking about here is we can still be sued whether you change this to official acts or not. That doesn't prevent lawsuits from happening. But what it does do, i.e. Full transparency here, got sued because we had a deputy had a sexual act with a inmate. We were sued. We won that lawsuit because they weren't trained to do that. They were told not to do it. They committed a crime. They went to prison. However, a federal judge is debating whether or not we should have to pay for all of the defendant's attorney fees because of this statute. And so that's why we're introducing it.
Thank you. And Sheriff, if you're able to wait until we hear from the other
Absolutely.
proponent conferee for questions from the committee.
Absolutely.
Thank you. Appreciate it. Thanks for your testimony. Next, we will hear from proponent conferee Don Peterson on behalf of the Kansas Trial Lawyers Association. Please introduce yourself and welcome to committee. Do we have Dawn Peterson on WebEx? No, nobody's there on WebEx. Okay, so then we'll just consider that written testimony. Are there any other persons wishing to testify as proponents on the bill? Not seeing any, then we'll open it up for any questions for Sheriff Easter. Not seeing any, then you got off pretty easily today, Sheriff. So do appreciate your service to the state and all you do to keep Kansans safe. And thank you for coming to committee today for your testimony. I appreciate it. Are there any persons wishing to testify as neutral or opponent on House Bill 2155? Not seeing any, so we will close the hearing on House Bill 2155. We're going to open the hearing on House Bill 2212, increasing the reimbursement, but actually I don't see the conferee here, so we're going to circle back to that. So we'll go ahead and close the hearing on House Bill 2212 and to consider that at a later time. And then that brings us to opening the hearing on House Bill 2062, providing for child support orders for unborn children from the date of conception. And with that, a bill brief from the reviser.
Thank you, Madam Chair. House Bill 2062 provides for child support orders for unborn children from the date of conception. Section 1 amends KSA 2165. This is the statute that requires the Supreme Court to adopt rules establishing the child support guidelines. Current law there in subsection B requires the court to consider certain factors in adopting those rules, and this bill would add an additional factor, which would be the direct medical and pregnancy-related expenses of the mother. New subsection C provides that the maximum amount of child support to be ordered for the support of an unborn child shall not exceed the direct medical and pregnancy-related expenses of the mother of the unborn child, and that those pregnancy-related expenses shall not include any costs related to an elective abortion. New subsection D provides that the amount of child support determined for the support of a child shall be calculated from the date of conception of that child, and then it provides the interest provisions. Section 2 amends KSA 23-2205. This is a part of the Kansas Parentage Act. Current law there provides that the parent and child relationship means the legal relationship existing between a parent and a parent's biological or adoptive parents, incident to which the law confers or imposes rights, privileges, duties, and obligations. It includes the mother and the child relationship and the father and child relationship. And new subsection B provides that for the purposes of this section, a child would include an unborn child as defined in KSA 23-3001. And then section 3 amends KSA 23-3001, which is the part of the Kansas Family Law Code requiring the court to make provisions for the support and education of minor children. And then the new language in subsection C there provides the definition of unborn child, which would be used in the previous statute. It cross-references, but the definition there is a living individual organism of the species Homo sapiens in utero at any stage of gestation from fertilization to birth. And I can take any questions.
Thank you. Committee questions. Senator Bowser.
Thank you, Madam Chair. I think I have some questions here. I'm trying to figure out conceptually how this would work. So we have a couple, they had an interlude, she becomes pregnant, the couple separates. How do we determine the date of conception, I guess, or is it a month? And then there would have to be some court order. She would have to go after the man get some court order that says he is responsible for the pregnancy care. Can you talk to me a little bit about how conceptually that would work? Thank you.
Thank you, Madam Chair. Senator Bowser. Yes, so they would have to determine parentage of the father. This statute doesn't specifically speak to that, but the Parentage Act does talk about how you determine that. And so that would have to be established for that child support order to be in place. And actually, KSA 232215, subsection C, already addresses this because it provides that those child support orders can include the payment of necessary medical expenses incident to the child's birth. So that's, in current law, the way they can figure that out. But you would have to have that court order establishing the child support, and then it would go back to that time. In terms of the date of conception, the bill doesn't speak to how that would be calculated.
Thank you. Senator Klemp.
Thank you, Madam Chair. So do we already do this post-birth to identify the participants?
Madam Chair, so the way that it would work now is, you would have a child, once paternity is established, however that's established, then that child support order can be put in place, and it can go back and capture, under the current child support guidelines and the statute that I cited, it can go back and capture those direct medical expenses that are incident to the child's birth. That's what's already allowed in current law.
Okay, this is just moving it forward in the process to while it's in the womb.
In theory, as long as you can establish parentage, and then the language is changed slightly to include the direct medical and pregnancy-related expenses of the mother.
Thank you.
Thank you. Senator Titus.
Thank you, Madam Chair. I see there is a definition for unborn child. Then in the second section, there's a reference to another definition of unborn child, but it also appears like unborn has been struck by the House in edits. Is all of that still coherent, or do we need to look at the definitions there?
Madam Chair, so let me kind of explain what the House amendment did. So the House Committee of the Whole amendment struck the language on page 1 in line 26. So if the child is an unborn child. So it used to say the direct medical and pregnancy related expenses of the mother if the child is an unborn child. So the reason in subsection D that was stricken is because it directly calls back to subsection B10. And so you're striking unborn from B10. So just to align that better, that's why that language was stricken. But the term unborn child is still used in subsection C. So that definition would still be used as the cross-reference definition.
And then is the term elective abortion defined anywhere else in statute?
I brought up all my unborn child statutes, but I did not bring the elective abortion statutes. So let me take a look at that when I sit back down.
Thank you.
Thank you. Senator Haley.
Right along that same line, Madam Chair, thank you that Senator Titus was referencing, and thank you for the review to this extent. There's an attempt, apparently successfully, to redefine fetus. Do you have, or do we still have, where do we have in statute what a fetus is? Fetus is up to a point, at least we've always learned, in gestation, to the point that there's viability, after which that viability could be considered a child. Is fetus, has that been struck from cross-referencing, the actual real terminology to be replaced with this unborn child? Do you know where else fetus is found in our statutes so that we might retain that which actually we're talking about?
Sure. Thank you, Madam Chair. So the statutes that we're dealing with here don't talk about fetus currently. So we're not making any change in these statutes. These statutes are more in the family law code where we're talking about child support guidelines and determining of parentage. So I would have to look at any other statutes that reference the term fetus to know, but none of the changes we're making here would have a direct impact on any of those statutes.
Thank you. And Madam Chair, Natalie, the other concern I have is the definition of a mother prior to the birth of a child. I mean, are there any other references? Again, we're changing, or there's attempting to change, well, what's always been real to, fill the vacuum of what those hope to be. But the definition of mother, has that ever been for, in any other statute where there's actually, the child is not, there's not a living born child?
Madam Chair, Senator Haley, I'm not sure about that. I'm not sure if we actually, I'd have to go back and look at the different definitions that are used throughout the Parentage Act. We're not defining mother here in these particular statutes, but let me see if there is we're certainly referencing mother, but not providing an actual definition of it. So I can go back and look at those statutes and see if one of them would have a definition of mother that would be applicable here.
I was concerned for the construction and the changing of words, just and how that impact could be where in fact there's nothing to support those changes except the desire for some to so do it. So thank you. And thank you, Madam Chair.
Thank you. Senator Schmidt.
Thank you, Madam Chair. How would this be applied in a situation where you have a woman who's pregnant and the biological father is out of state? There's plenty of scenarios I can imagine, especially with military families in the state, or just, or the biological father is, leaves. How would it be enforced, or would it be able to be enforced?
Sure. Thank you, Madam Chair. So we have a whole separate article on child support enforcement, and we have relationships with other states to support enforce child support orders. So this would just be a child support order, just like any other child support order. So it would be enforced pursuant to those statutes.
If I may, Madam Chair, is there, are we absolutely positive that other states would recognize this, knowing that it's not a provision that I'm not aware exists in any other state?
Madam Chair, Senator Schmidt, I'm not I'd have to do some research on that to see what those enforcement relationships look like and how those orders are enforced across state lines.
Thank you. Committee, other questions for the revisor? Not seeing any, then thank you very much. Appreciate it. Committee, we have 4 conferees wishing to testify in person. So I want to make sure we have enough time left for questions, if any, from the committee. So we're going to ask each of the conferees to limit your testimony to 5 minutes. So, and I'll hold up the folder to indicate there's 1 minute left. So, and if you don't see me, then I'll kind of prompt you on the microphone. So just so you can finish your thoughts within that last minute. So the first proponent conferee we'll be hearing from is Brittany Jones, Director of Policy and Engagement, Kansas Family Voice. Please introduce yourself and welcome to committee.
Good morning, members of the committee. Chairman Warren, excuse me, I have the wrong name written down in my testimony. My name is Brittany Jones. I'm the Director of Policy and Engagement for Kansas Family Voice. I'm also an attorney. We care deeply about ensuring that women who are in difficult situations receive the support that they need. HB 2062 is a very simple way to ensure that courts consider pregnancy-related expenses for a child during child support judgments. And thank you for the opportunity to share why we support HB 2062. Before I get into my prepared remarks, I did want to address 2 questions that I heard that were asked the revisor. First, we do have a definition of mother in our code already. It's in a different section of the code, but it was passed in SB 180 several years ago, and I don't know the code section off the top of my head, but it is in that bill. And secondly, regarding, there was, Senator Titus asked a question, and I'm trying to remember what it is right now. It just left me, but it will come back to me. and I will get to it when it comes back to me. Or you can ask me a question later. But SB 180 is where that's on. Oh, it's about elective abortions. There we go. Elective abortions is defined in other places in our statutes. I also don't remember the statute off the top of my head, but I can find it when I sit back down, if the revisor doesn't find it before I do, which she probably can't. But anyway, HB 2062 does not break any new ground. Like you heard from the revisor, it is simply ensuring that throughout our code sections on child support, that we are recognizing that the mother has pregnancy-related expenses, not just birth-related expenses, and just clarifying that. We also know that many courts already award these sorts of judgments to mothers to make sure that their pregnancy-related expenses are recognized. We want to make that a consistent consideration. It doesn't mandate that they provide that sort of award. It just asks that they consider it. So we already know this is happening. We do know that at least 4 other states have similar laws to this, and we know this has been happening in Kansas in an inconsistent manner. So we want to make it a consistent thing that judges are considering. Kansas statutes have recognized the child in the womb for a multitude of purposes, both in our civil and our criminal code, since the 1930s. So that recognition, that definition that you see on page 2 is nothing new. It is in our code in multiple places in both kinds of, in both areas of our law. And I'm happy to go through those statutes if the committee would like for me to. So according to the most recent numbers, more than 12,000 women in Kansas gave birth in the last year who were unmarried. Now, that's not saying that every single one of those women is seeking some sort of child support judgment, but that is probably the body in which, the pool in which we're looking who might be in some sort of child support discussion with the court. Many of these women have been a party to custody and child support proceedings. These are the women, this is the group of women that we want to support throughout their pregnancies. Expenses for a child do not start once a baby is born. We all know that. There are a multitude of doctor's visits and other expenses that a woman might need to undertake prior to actually giving birth. And it may sound obvious, but cost will vary. And it is clear that women who are pregnant and give birth bear the health expenses that women who are not pregnant do not bear. It is important that the father of these children share in these expenses. A father doesn't become a father at the moment the baby is born. A father is a father from the moment of conception. And so we want to recognize that and make sure that he is supporting the woman who's carrying his child during this time. Also, HB 2062 does not change how we determine paternity. Like the revisor said, there's already methods for that. It also doesn't change enforcement. There's already methods for that. We are simply adding a consideration for judges when they make these awards. So it doesn't change any procedures. It doesn't change any judgment. It's not a radical bill. It's a very simple bill to ensure that women know that when they're in this situation, that they will have this support considered. So we believe that every woman should be surrounded by a system of support, and pregnancy is no exception. In fact, pregnancy is when a woman most likely needs this support. Fathers are still fathers, even if a child is not yet born, and our law should reflect that reality. All this bill does is require a court consider giving a woman a support to cover her pregnancy-related expenses. And I ask that you support HB 2062, and I will stand open for questions at the appropriate time. Thank you.
Thank you. Yes, if you're able to stay until we hear from all the proponents in case there are questions from committee, that would be great. Thank you. Next, we will hear from, I lost my sheet. Here we go. From Jean Gadoon, Director of Government Relations, Kansans for Life. Please introduce yourself and welcome to committee.
Thank you, Chairwoman Warren and members of the committee. I'm Jean Gowden, Director of Government Relations with Kansans for Life. I appreciate the opportunity to testify in support of House Bill 2062. As the previous conferee mentioned, there is a large number of women who are giving birth to children while they're unmarried. And according to the 2023 data from the Kansas Department of Health and Environment, that's 36% of all live births were to single moms. And also, nearly 83% of all abortions were performed on single women. So many women who are facing unexpected pregnancies do choose abortion because of financial insecurity or uncertain relationships. And we have found that out from various studies that have taken place asking these women What are the reasons for them to have an abortion? And they also say 2/3 of these women in another study had also said that if they had received the financial or relationship support that they were desiring, they would have preferred to have their babies. So these women deserve the utmost help in their time of need, including support from the father of the child. House Bill 2062 addresses some of the financial concerns that pregnant women may face by instructing the court to consider those direct medical and pregnancy-related expenses when establishing the guidelines for child support payments. And while it may be that the paternity is not known before the birth of the child, once it is established, the court may make child support payments retroactive to include expenses incurred by the mother during the time when her child was unborn. Once again, want to reiterate that no woman should ever feel that abortion's her only option, and House Bill 2062 may help alleviate at least some of the financial stress that a pregnant woman may face at a critical time for her and her child. I appreciate your consideration, and I respectfully ask that the committee pass House Bill 2062 out favorably. Thank you.
Thank you. Are there any other persons wishing to testify as proponents on House Bill 2062? Not seeing any. Then I want to direct committee to you have at your desk proponent written-only testimony from Lucretia Nold, Public Policy Specialist, Kansas Catholic Conference. And with that, we'll open it up for any questions from the committee. Senator Corson.
Thank you, Madam Chair, and thank you for being here for that testimony. This is certainly an important topic. I wish we had more time to spend on it, but I want to be respectful of the limitations. Last year, we had a respectful back and forth about the fetal personhood implications of this bill, which I'm still very concerned about. I'm going to leave it to the opponents whom I anticipate will address those concerns, but I certainly share them, and I think that they're very real, and we shouldn't dismiss those. But I wanted to focus this year on kind of two issues that I'm concerned about around the implementation of this. And the first would be, how is a woman to go into a court of law and have the date of conception determined? Because it seems to me like that's something it's almost impossible to determine. The bill says from the date of conception. So what I worry about, and what I think a lot of Kansas women would worry about, is setting up a procedure where women are going to have to go into a court of law and submit maybe an affidavit or something that says, here are the dates that I had intercourse, and here's who I had intercourse with. And I think that, frankly, that would be really terrifying to a lot of women to have to submit that kind of a document in a public court proceeding. But I'm not aware of a better way to figure out how we would determine precisely the date of a conception, how we're asking a court to do that. So that's my first point. And I can pause there if somebody wants to answer that. I also have a second point I wanted to make just about the administration. I'll go ahead and just make it, and then you can respond. The second point is just about the administration. I think that this is just asking a lot of our district court judges who are going to be hearing these cases, because what I worry about is how are they going to interpret what are pregnancy-related expenses. I think this bill really isn't quite ready for prime time because it doesn't really flush out what those expenses are, what is considered a pregnancy-related expense and what isn't. And I worry that different judges are going to interpret that very differently across the state. And I mean, a couple examples that I just thought of, as I was sitting here, like if a woman wants to buy maternity clothes, for example, is that considered a pregnancy-related expense that would be covered? I think reasonable people could disagree whether that should be covered. Something about like, for example, if a woman is ordered on bed rest and a doctor says you need to be on bed rest for a certain number of weeks and a woman can't work during those weeks, is the father then responsible for the lost wages that woman would have otherwise earned? Again, I think reasonable judges are going to interpret that differently. So those were the 2 points that I would appreciate a response to, and I thank everybody for being here. Thank you, Madam Chair.
Ms. Jones, do you want to answer those? And please introduce yourself.
Gladly, thank you. Brittany Jones, Kansas Family Voice. Thank you, Chairwoman Warren and Senator Corson. Happy to answer those questions. They're very practical questions. This bill when we're determining the date of conception, essentially those pregnancy-related expenses would begin when the woman went to the doctor and had that determination that she was pregnant. Generally speaking, and the bill does not directly address this, but it's a practical question, so I'm trying to address it practically. But generally speaking, a doctor determines an approximate date of conception, and that's how you determine the due date of the child, all of those things. And so that's a medical decision. No one is going to have to go in there and share a ton of personal details. Unfortunately, these sort of proceedings do tend to get very personal, but this is not something that has to be super personal. It's a very simple determination that the doctor's office makes. From my understanding of the law, that's all they would need to present to the court. To the second question, exactly what is a pregnancy-related expense? Normally, we're talking about direct medical payment or direct pregnancy-related expense, which would be a lot of those doctor's visits. But the true answer to that is that's up to the court. The courts have been wrestling with this question for a long time. This is not a new question they've had to wrestle with. They look at each situation. They determine, in the totality of the circumstances, what are the costs to the woman, but also, what does this mean for the father? What is his situation? And so our recommendation is that this body should not be mandating exactly how a court should be making those determinations. It is best left to them to look at each situation and determine what is most appropriate.
Thank you. A follow-up question from Senator Corson.
Thank you, and thank you for that, Ms. Jones. Based off your response, would you consider it to be a friendly amendment if we changed date of conception to date the pregnancy is determined or something of that nature? I'm thinking of what the exact language, but if we moved away from that date of conception to saying the date of a positive pregnancy determination, something to that effect, would you be open to an amendment along those lines?
I would have to see what that would look like and what it looked like in the code. Date of conception is something we see already in our code, and so that's why it was used.
Okay, thank you for those responses. I appreciate it. And thank you, Madam Chair.
Thank you. Yes, Senator Schmidt.
Thank you, Madam Chair. Follow-up question from that. I guess I'm just a little surprised to hear you be okay with a wide range of disparate outcomes that we could have in courts all across the state. And we've had lots of hearings in this room about the difficulty of, just having fair access to the courts all across the state, whether you're in Kansas City or Topeka or Kiowa County. So I guess that's my concern, that we're going to have a range of disparate outcomes as a result of this law that, like Senator Corson said, I think maybe is not really ready for prime time.
Chairman Warren, Senator Schmidt.
Please go ahead and reintroduce yourself. So,
excuse me. Oh, yes.
Yes, thank you.
I'm Brittany Jones, Kansas Family Voice. Outcomes versus and access are two different things. Court access is a completely different question that is outside the scope of this bill. When it comes to child support outcomes, those do have to be determined on a case-by-case situation. There are very rarely any two women or any two couples that enter a courtroom in a child support proceeding that have the same situation. And that is why it is up to the discretion of the court. And I believe that the court would probably look very disfavorably upon a law like this if you were to start telling them exactly what to do. It's in their guidelines. And that's why we put it in that section. It's for their consideration. And they get to look at each situation and determine how best to apply it.
Thank you, Madam Chair. And then follow up to that question, understanding some of the implications to a bill like this, wouldn't it, if something like this was to pass, wouldn't it be appropriate that we also consider life insurance policies for the fetus if we're recognizing the expenses that pregnancy can carry?
Chairman Warren, Senator Schmidt, I believe what you're getting to is we have in other sections of the code where an unborn child can be recognized for benefits from certain insurance things. And so it's outside the scope of this bill, but is already in our code.
Thank you. I have a couple of follow-up questions to that. So if I'm understanding the bill correctly, in Kansas already, for child support orders, we have a list that the court shall consider as factors, including, and there's a list of 9. It's on page 1 of the bill. And what the bill does is adds number 10, which is the direct medical and pregnancy-related expenses of the mother. And so is it your testimony then that courts are already used to taking into account these relevant factors, the 1 through 9, and this would be a 10th one that they would then, in the child support order proceedings, take into account as well?
Thank you, Chair Warren. That's exactly correct. These are already, this is a list of suggested things for them to consider, or it's not suggested, it's a shall. They shall consider, but it is not a mandate that they necessarily award those things, but it does mandate that they consider them. And so they're very used to this list, but it's not an exclusive list. That's why they are already in some courtrooms considering these pregnancy-related expenses. We just want to make that a consistent consideration.
Because, yeah, I see it says on line 15, including but not limited to, and then it lists the 9, and this would be number 10. I have another question looking at the written testimony. Some of the questions I see in the opponent testimony is that it's an attempt to sneak the concept of fetal personhood into state law, and then I see also that, and you mentioned too that in our statutes already, we we do recognize in the criminal code the application of crimes to the unborn child, and then also the unborn is allowed as a trust beneficiary, and wrongful death of person includes unborn child. And in 65-6732, human life begins at fertilization. And so could you address, we already have this in our, we already have not fetal personhood, but we already have unborn child being recognized as, could be a victim of a crime, allowed to be a trust beneficiary, allowed to have a wrongful death action brought on their behalf, and then the definition human life begins at fertilization. So when we see, is this an attempt to sneak the concept of fetal personhood into state law?
Chairman Warren, absolutely not. This is something that we have had in our code since the 1930s. In fact, the recognition of the unborn being allowed to be a trust beneficiary has been in our code since 1939. All of this was in our code when the Kansas Supreme Court created a right to abortion in Hodes and Nowser versus Schmidt in 2019. So this is absolutely not an attempt, has nothing to do with personhood. This is simply ensuring that the mother can receive that child support award when the child is still an unborn child, or for those, unborn child pregnancy-related expenses. And you need to recognize that child for a child support award. And so that is all this bill is doing. It is not an attempt to expand out any further than the statute. It is doing what our law already does and recognizing that child in a very simple way.
And as a practical matter, then, looking at current statutes, the paternity would be determined as in any other child support award case. The paternity is determined. Is that right?
Chairman Warren, okay. Absolutely. We are not changing any way the paternity awards or paternity is determined. That is a different section of the code, as the revisor alluded to, and we are not attempting to change that.
Thank you. Senator Clays.
Thank you, Madam Chairman, and thank you for coming today. And this seems like a pretty straightforward and reasonable piece of legislation. I guess one of the edge cases that I was thinking about is, what if in a case where someone thought they were the father and did step up, as the legislation asks of the father, but then later finds that he was not, in fact, the father. Is this legislation? Should we have something in here, or is that already handled somewhere else, or what? Just give me your thoughts on that.
Absolutely, Chairman Warren, Senator Clays, and the revisor may be able to answer this better than I can. That is beyond the scope of this bill. I'm 95% positive that the court already has means of dealing with that situation. That's the reason why we have a specific way of determining paternity, so things like that don't happen. But I believe that if that did happen, the court has a method for dealing with that, but that's beyond the scope of this bill.
Thank you. Senator Rose.
Thank you, Madam Chair. In light of the concerns that another senator brought up as far as the privacy of the mom, it would be optional for a woman who's pregnant to receive child support, correct? So if she was concerned about divulging certain information in the court, she wouldn't have to.
Chairman Warren, Senator Rose, absolutely. A child support case is an optional decision that the woman makes, and so unfortunately these cases often do get messy beyond the scope of the bill, but unfortunately, a woman has to be prepared to receive any child support to divulge certain things to the court, and so it doesn't change anything about that process.
Thank you, Madam Chair.
Thank you. Not seeing any other questions, then thank you for your testimony today. Appreciate it. Committee, next we will hear, are there any neutral conferees wishing to testify? Not seeing any. So next we will hear from opponent conferee Taylor Morton, Kansas lobbyist and policy analyst, Planned Parenthood Great Plains Votes. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, and thank you, members of the committee. My name is Taylor Morton, and I'm the Kansas lobbyist and policy analyst with Planned Parenthood Great Plains Votes, which is the advocacy and political arm of Planned Parenthood Great Plains. I'm here today to voice opposition to House Bill 2062 on the grounds that this bill would further codify fetal personhood language into Kansas law, which is a means of advancing an anti-abortion agenda despite broad public support for reproductive rights and abortion access in our state. House Bill 2062 also raises serious questions bureaucratically and financially. Kansas is experiencing a serious maternal health crisis for which evidence-based policy solutions are needed. And House Bill 2062 is simply not an effective means of providing meaningful support for pregnant and parenting Kansans. On the surface, this bill appears to be a means of supporting pregnant people and families, but in reality, it is an attempt to advance an anti-abortion agenda by further codifying that fetal personhood language into Kansas law. And this could pave the way for laws that criminalize or restrict health care during pregnancy down the road. Kansans have made it clear that they do not want their reproductive health rights restricted, and this bill is in opposition to that broad public support for abortion access in our state. Furthermore, House Bill 2062 does nothing to provide meaningful support to pregnant people in Kansas, and the lack of clarity in this bill presents some serious challenges to implementation. A pregnancy-related expense, for example, is not clearly defined, and exactly when a pregnant person would be eligible to seek child support would be nearly impossible to determine, again, because determining that exact date of conception would be incredibly difficult and raises those significant privacy concerns that have already been raised. A positive pregnancy test doesn't always indicate the birth of a child, and House Bill 2062 sets forth no meaningful structure for child support payments during a pregnancy that end in stillbirth, miscarriage, abortion, or adoption. As I mentioned, there are serious challenges to the implementation of this bill, for example, in contracting for in utero genetic testing, as well as the administering of said in utero genetic testing. The fiscal note for this bill states that current federal regulations do not provide for or allow for parentage establishment prior to the birth of a child, which means that state general fund appropriation would be needed. And DCF would likely have to contract for in utero genetic testing in some cases, which could average $1,750 per instance. So implementation of this bill would put undue strain on our state's budget and resources, and it is simply not an effective means of supporting pregnant Kansans. Like I said, in Kansas, we are experiencing a serious maternal health crisis, and Kansans need policy solutions that provide meaningful support for pregnant people and families. My written testimony includes a list of some examples of such evidence-based policies, and I'll name a few now. Like I said, refer to my written testimony for that longer list. Increasing benefit levels of and expanding eligibility for safety net programs like SNAP, WIC, and TANF. funding for community-based organizations that work to improve Black maternal health and address racial disparity in pregnancy and birth outcomes, funding for VA health systems to support pregnant and parenting veterans, and again, refer to my written testimony for a longer list. And this is by no means an exhaustive list. Kansas families do need meaningful support from the legislature. And in order to support pregnant and parenting Kansans, the legislature should focus on evidence-based policies like these, especially considering that existing statute already allows courts to consider medical expenses incident to a child's birth in child support determinations. So I urge the committee to consider what I'm saying today, that further establishing that fetal personhood language into Kansas law could set a dangerous precedent that goes against the will of Kansans, that the implementation of this bill raises serious financial and bureaucratic questions, and that Kansans do need real policy solutions that provide meaningful support during pregnancy in ways the House Bill 2062 simply would not. So with that, I do urge you to oppose House Bill 2062. Thank you, and I will stand for questions when appropriate.
Thank you. Next, yes, if you could please stay in case there are questions from the committee at the end of all the conferee testimony. Next, we will hear from Melissa Steiler, Loud Light Civic Action. Please introduce yourself and welcome to committee.
You pronounced my name right. Chair Warren, members of the committee, thank you so much for allowing me to be here today. My name is Melissa Steiler. I'm the Advocacy Director for Loud Light Civic Action. We're a nonpartisan nonprofit organization that focuses on building civic engagement and leadership in young Kansans. We've got over 12,000 supporters across the state, including in every one of your districts. And with respect to the freedoms guaranteed by the Kansas Constitution and the mandate that was put in place by Kansas voters in 22, we deeply oppose this legislation. Our primary concern is, this bill is dishonest and it's conniving. If this were just about child support, it would not raise alarms for me. But what's clear whenever you look at the devil's in the details here, that one of our core values of government transparency is being violated with all of the additional language that's part of this bill outside of the child support stuff. And so the actual impact of it would be chipping away at legal protection of abortion. So if this bill is about child support, then it would be redundant. We all know it has been established by even proponents today that the courts are already able to take pregnancy-related expenses into account. There was an amendment in the House that cleaned up all the extra language and just made this a court directive. Whenever that happened, it was rejected, of course, and Representative Humphreys actually said, I want to make sure I get my quote right here, that the clean and direct language that only dealt with child support and just having that be the bill, a clean bill, gutted the bill, and that it really takes away from the heart of the bill, is the quote that she said about this. And my real question is, if child support is not the heart of this bill, then what is it? Presumably, we can only assume that the fetal personhood language that is in this bill was the goal all along. And so looking at that, all that's left outside of child support is this fetal personhood language. It's the laws of establishing legal precedent that a fetus has more rights than a pregnant person. And this isn't a secret. National anti-abortion extremists are open and honest that this is their intention whenever they're talking to their supporters, whenever they're talking about bills like this. It's not a new tactic. This year alone, there are over 20 bills that have been introduced like this all across the country. Last year, it was over 40. And if, in the case of 2062, it would establish fetal personhood in family law, which doesn't exist right now. And I know proponents have said that this isn't a big deal because it's in other parts of law. But the thing is, maybe it's not a big deal to us, but it is a big deal to the courts. And in fact, the stacking of this kind of language throughout statute is the legal basis that the notorious Alabama ruling criminalizing IVF used whenever they made that ruling. It was because, death by 1,000 cuts. And so all of this combined together leads us to believe that HB 2062 is not about the well-being of a pregnant person. It is a tactic being used to try to break down our constitutional protections against the will of the people of Kansas. And so I'll just close out really quickly in saying that consistently the people who are calling for this bill are exclusively anti-abortion special interest groups. In the House hearing, there were 3 proponents. There were over 80 opponents. The proponents were all paid lobbyists. The opponents were real Kansas voters. I expect it to be similar for this hearing as well. And if this were a real problem, that women weren't able to ask for child support, that they, on a case-by-case basis, weren't getting their needs met through the court system, then where are other proponents of this bill? Where are the experts in family law? Where are the people who would be directly impacted by it? Where are family lawyers? They're not here because this bill isn't about that. Many members of the legislature concern themselves with the sexual and reproductive health of the citizens of our state. We also want our citizens to be healthy. And so with that, we would like to remind the legislature one of the most important rules of consent. No means no. The people of Kansas spoke loud and clear when they rejected the legislature's constitutional amendment to revoke the right to an abortion back in 22. And if this legislature is unable to respect that, then we ask that our lawmakers at least be honest about their intentions and put their name and their support behind a bill to ban abortion, because that is the real impact of bills like this, and at least you will be open and honest with voters so that way they know what you are doing while you are here in Topeka. Thank you, and I can stand for questions.
That was 5 minutes, so everybody did a good job with the time, so appreciate that. Okay. So see, there you go. Committee, I want to draw attention that at your desk, you also do have opponent written-only testimony from Laurel Birchfield, Advocacy Director, Mainstream. Is that Mainstream Coalition? Mainstream? It just says Mainstream. Rashane Hamby, Director of Policy and Research, ACLU Kansas. Michelle Bennett, MD. Joseph Nichols, private citizen. Molly Kepler, private citizen. Jerry Graham, private citizen. Amber Schmidt, private citizen. Suni Michelson, Amy Moore, Lynette Compton, Danielle George, Savannah Gerardo, Kelsey Nye, Drew Nye, Trina Soderling, Melody Monroe, Abriana Markham, Matthew Reimer, Kelsey Grove, Mackenzie Kreider, Amanda Jones, Brianna McDaniel, Gracie Brush, Paris Raitt, Rachel Motley, Andreas Brass, Alyssa Dans, Austin Vodder, Miranda Sue Tenove, Heather Walstusk, Elaine Swan, and Jonathan Smith. And my apologies for mispronouncing any of those. So committee, we will open it up for any questions. Senator Shane.
Thank you, Madam Chair. My first question will be for Ms. Styler. Just to clarify, is it your official testimony in front of this body that members of the legislature are dishonest and conniving?
Please go ahead and introduce yourself.
Melissa Styler, Loud Light Civic Action. This bill is dishonest and conniving. The way that it's being framed, it's whenever there is no honest discussion about other impacts, and there is active conversation denying the real impacts that this bill would have. I am not saying that there is any individual legislator who is trying to bamboozle the public, but I am saying that this tactic is being used by incredibly well-funded national special interest groups, that it's happening all across the country, that they are very open and honest with what they are doing and why they are doing it. And to not even be able to discuss that open and honestly here seems like it's not transparent. And additionally, by rejecting the amendment in the House, and I know that you all, like if you wanted to clean up this bill, then I would be very pleased with that. But by rejecting the amendment in the House, that took away all this extra stuff that so far the debate has said this bill isn't about any of that extra stuff. It's only about child support. And to clean up the bill to make it only about child support And for that to be rejected without any explanation for why all that extra stuff is needed, why that extra stuff is, quote, the heart of the bill, that is not transparent to your voters. And so I'm talking more about the tactics than about any individual legislator, whether it's a point of confusion or it is, I believe that the people who come here to Topeka are trying to do good work the best that they can. And I think that being transparent about all of the impacts of the legislation that you passed here is important to the voters of Kansas.
May I continue, Madam Chair? Thank you. I would say that your suggestion would actually directly impugn the integrity of members of this legislature, so I would disagree with that assertion. What financial responsibility does a father have in regards to a pregnancy?
That's outside of the scope of my area of work and my mission statement. Our general core focus on this bill is, first, government transparency. Second, respecting the will of the voters. I believe, as proponents of this bill have said, as you all have said, that family law is determined on a case-by-case basis. And I believe that parents are responsible, both the mother and the father. This bill doesn't actually address that. It doesn't, as proponent testimony has said, and I quote, "This bill does not mandate any method or modify the court's procedures regarding this," meaning child support, "in any way. The court is still allowed to use its discretion in making these determinations." I believe that that is right. And if this bill only did that, if it only added, adjusting the child support section of law, then I wouldn't be very alarmed about it at all. It would be a boring bill. But all the extra stuff on top is what makes it concerning.
I guess, could you clarify what the extra stuff is? I guess I see this as explicitly adding consideration for pregnancy-related expenses. So I guess I'm trying to understand what the extra stuff is.
So I don't have the bill in front of me right now, but I can tell you from, and I could send you this information, though I imagine, frankly, you all probably have it in front of you now. If you look at the House debate on this, there was an amendment that was just striking the additional language that dealt with anything other than child support. So some of the things that they struck from the bill was redefining abortion or elective abortion. One of the issues with that, and actually I couldn't get to this in my testimony because of time limits, but this kind of definition can cause a lot of unintended consequences and harm, and we've seen that in other states as well. So by redefining abortion as an elective procedure, unless it is to prevent death, that language in other states has caused serious maternal health care issues because the risk of death isn't always certain. And there are other risks, serious medical risks with pregnancy that may not result in death. And so whenever you're defining things in such a narrow scope, there's unintended consequences beyond that. And so by removing all of, I could, again, bring up the amendment that was offered on the floor and send that to you all, shortly right after this. But removing all of that extra language and just making a clean bill, that would be great. That's something that wouldn't alarm me at all.
Does risk of death mean certainty of death?
The thing is we've seen that, so for example, when there is not clarity, decisions are made during high-risk situations that can harm people. So for example, whenever trigger laws went into effect in Missouri and abortion was banned there, my best friend lives on the Missouri side. She's a mother, she's married, she's very happy, she has children. She also has a chronic condition that requires a medication, a lifelong illness that requires a medication that could cause risk of miscarriage. She has had over a dozen surgeries for this chronic condition. This medication saves her life. Once those trigger laws went into effect that banned abortion in Missouri, she was no longer allowed to have that medication because she was of childbearing age and because it could potentially induce abortion with her taking it if she were to get pregnant, even though her husband had had a vasectomy and they had no intention on having more children. That was cleared up. But that was the case for a couple of months while her doctor's lawyers were figuring out what the laws meant. And so whenever we have that unclarity, even if they're wrong, the fact that doctors are going to have to question that in moments that could be life or death, that is something that is incredibly scary to me, and it's something that's preventable by cleaning up the bill language here.
I would argue that there was some miscommunication, that an unintended consequence is much different than intentionally inducing an abortion, and I think that that has been significant harm caused across this country. One final question for you, or would it be your official testimony today that we should seek to have mothers and fathers disregard the personhood of their unborn child that's developing in the womb?
It is my opinion that the legislature's place is not to get in the middle of personal, private decisions between a mother, a father, their doctor, their faith, their family. And that is, hopefully, you mandating how couples think and talk to each other isn't something that is a goal that you have either.
Yes, other questions? I want to follow up on a couple of questions that have come up in the discussion.
Can I go?
Oh, yes, it's a question for the reviser. We're talking on page 2, elective abortion, and it's my understanding that that section of the bill was lifted and taken from current statute in Kansas. So could you clarify that, if that's correct?
Thank you, Madam Chair. That definition is used in 2 other sections, KSA 65 4A01, which is a statute about the facility licensure for abortion facilities, and then 42190, which is a statute about health insurance coverage and how that relates to abortion coverage.
So that section isn't any different than what's currently in Kansas statute?
Correct. There's no definition of elective abortion that would currently necessarily apply in Chapter 20 in these child support or family law section codes, but this definition is identical to the ones that are found in those 2 sections about insurance and abortion facilities.
Thank you for clarifying that. Are there any other questions? Not seeing any. Are there any other persons who wish to testify as opponent conferees on the bill? Not seeing any, then I want to, before we close this hearing, want to state that it, I believe, is the intention of every legislative committee up here to open and honestly and transparently conduct their business in hearings, and to suggest otherwise, I think, is not very accurate, and that when committees hear bills, it's they're brought from many different sources. So to say that the legislature is doing this and that and not being open and honest as a blanket statement, I do take exception to as well. And on behalf of this committee, we do work hard to conduct our hearings fairly, give everyone an opportunity who wishes to be heard, and that's what we do here in Senate Judiciary Committee and in our other legislative committees. I don't serve on all of them, but that's the goal of each and every committee here. So with that then, I want to thank the conferees for their testimony today, and we will then close the hearing on House Bill 2062. With that, committee, then we do have an opportunity for possible final action on bills previously heard. We're not going to do that today, but if you do have some amendments on bills as we're hearing them, make sure you get those ready, because we're kind of on a short timeline. You'll see we're going to be busy every day with the bills that have come over from the House, and want to make sure that we're ready to get our work done on time. Our last opportunity to meet is Monday, March 17th. So with that, I want to thank everyone for their attention and for following along, whether in the committee meeting room or online. And with that, then, the meeting is adjourned.